morning, and thank you for signing up for this personal injury update CPD unit. My name's John Birchall. I'm a barrister. I'm not a practitioner. I make a living out of research, and I'm going to speak about developments in personal injury law for the past year or 13 months. I'm going to try to cover all of the key things which have happened, aside, of course, from quantum cases that you'll find in Kemp and Kemp. But maybe stand back a little bit and take a good long look at some of the big cases that have happened in the House of Lords in the personal injury field in this period. There was a particularly well-known case about pleural plaques, the ongoing litigation which comes out of asbestos claims. And I'm going to refer to it as Rothwell. It's also known, the first party in the House of Lords version of the case is Johnson. Rothwell is a second. And it's a case which you'll find the reference to, like all of the cases I mentioned, in the text. By the way, all of the quotations which I will refer to are also in the text, although a lot of the things I say, aside from the quotations in the cases, are not there. I'm going to read bits of those quotations, but probably not all of what you have written on the sheet. Back to Rothwell, pleural plaques, as you may remember, are a condition caused in the lungs by bits of asbestos dust, which in most cases, in 99% of cases, have no symptoms that the patient experiences. And several patients tried to claim, on the basis of having these plaques in their lungs, the plaques show that there's asbestos in the lung, and they show that there's a heightened chance of some other condition. They also cause worry, of course, to people who think that maybe they're in danger of getting sick. And of course, a big issue in this case was first, whether pleural plaques amount to damage. As I expect you all know, damage is an essential ingredient in the cause of action of tort, whether they amount to damage on their own. But the thrust of the appeal in the House of Lords was whether they amount to damage when aggregated with the heightened risk of other conditions and aggregated with the worry which they cause to the patients. And the House of Lords unanimously, in the Court of Appeal by a majority, Lady Justice Smith dissenting, decided that symptomless injury is not damage, is not actionable damage, so there's no cause of action. They also rejected the idea that when aggregated with the other problems, in other words, the heightened risk of other diseases and the worry, that they became damage. Now, this is a unanimous decision. It's a fairly simple point on the surface, but I think it's worth considering a little bit more some of the implications of this case. All of their lordships gave judgments, and 4 of them give some detailed reasoning. Lord Mance doesn't so much. He just concurs with Lord Hope in leaving open the correctness of Page and Smith. But to actually consider why there is a bit of a conceptual problem here, it's interesting to turn back to the judgment of Lady Justice Smith in the Court of Appeal. And she said that pleural plaques do amount to injury, and she gave 2 reasons. One is that in 1% of cases which do have symptoms, other than the fact that these things show up on the X-ray, then clearly pleural plaques are injury, so why not in the other cases? And the second point she made is that lesions on the surface of the skin do amount to injury, even small scratches, so why not when they're inside the lungs? And Lord Hoffman answered this objection by distinguishing injury from damage. Now, to say either Lady Justice Smith or Lord Hoffman is right or wrong about what these words mean doesn't really take us any further. The interesting thing is the underlying analysis of what damage is.